Welcome to the Texas Conflict Coach radio program. If you've ever experienced or engaged in destructive or unresolved conflict, then you know it leads to broken relationships, distrust, and damaging results. Our program will help you manage and resolve conflict effectively with strategies, valuable resources, and support. Since 2009, our radio program hosted guest experts from around the globe sharing their perspectives, experiences, and expertise while giving you food for thought. If you can't listen live, then download and listen to any of our 300-plus podcasts in our library at texasconflictcoach.com. So sit back, relax, or join the conversation every Tuesday evening, or tweet us at TXConflictCoach.
Have you always wondered what the difference between arbitration and mediation is? Join us and listen in today as attorney, mediator, and arbitrator Daniel Preston Dozier discuss the facts and fiction of arbitration. You'll learn the pros and cons of arbitration and how mediation is similar to and completely different from arbitration, and how both are different than going to court. Hello, I'm Stephen Kotov, your guest host, and joining me today for a program entitled To Arbitrate and Split the Baby or To Mediate in the Hot Tub is Daniel Preston Dozier. Many of our listeners will remember Dan from our prior shows on the high cost of going to court and the romance of litigation from our series entitled Mediate, Don't Litigate. If you don't remember, let me tell you a little bit more about him. Dan is a member of the law firm of Preston Dozier, LLC, based in Washington, D.C. He received his J.D. in 1971 from Wayne State University in Detroit, Michigan. He is an internationally recognized pioneer in conflict management and collaborative decision-making with nearly 35 years of experience as an attorney, negotiator, and mediator. Mr. Dozier has been admitted to the practice of law in Michigan, the District of Columbia, and Maryland, and is a member of the District of Columbia Bar and Maryland State Bar Association. He was an adjunct professor at Vermont Law School, where he taught environmental dispute resolution from 1989 to 2000. Mr. Dozier has also written numerous articles and monographs on dispute resolution topics covering stakeholder engagement collaborative processes to consensus building to mediation ethics. Welcome back to the show, Dan.
Thanks, Stephen.
So, Dan, I understand that you're not primarily an arbitrator. You're primarily an attorney and a mediator, but you've done some arbitration. You have some experience with it. Help us understand what you've experienced related to arbitration.
Well, Stephen, I've both represented parties in arbitration cases and have arbitrated both binding and then non-binding, which is a funny form of arbitration or of mediation, depending on how you look at it, and a number of other cases. So I've been around the block a bit on both arbitration and mediation. I tend to practice more as a mediator because the kind of cases I do are much more congenial to mediation, and that's what the parties tend to select.
Mm-hmm. Well, we're very lucky to have you on for our third show because you have all this experience. It's a great value to all our listeners. And you know, sometimes we don't really know what arbitration is. That's the purpose of the show. So, what is arbitration, Dan? And do arbitrators really split the baby?
It's interesting you asked that question. First thing, to define arbitration for a bit. Arbitration is simply where parties, by agreement, agree to have a third-party neutral, not connected to either party, decide the case for them. So if they're in a dispute and they go to arbitration, they can select who that third-party neutral is, and they do. But the neutral then, after hearing the evidence and hearing the case, makes a decision. So it's binding. And that's the key thing. You are handing your decision-making over to a party and over to a neutral or over to the arbitrator, which is what makes it like litigation in that that's what a judge does. But unlike litigation, suing in court, the arbitrators you select who the arbitrators are, and you can pick people with expertise in particular fields or engineering background as opposed to an attorney or whatever. So arbitration is very common. It is the sort of the original form in the United States of alternative dispute resolution, and it's been around for a very long time. But arbitration has gotten a bad reputation in this country for a couple of reasons. One is many attorneys perceive that arbitrators so-called split the baby. Rather than making a decision completely on the merits of the way it's perceived that judges do, many attorneys are afraid that arbitrators will try to, come down halfway in between the case and not really decide it cleanly. Is that true? I don't know. I don't think so. Not as often as people think it is, but I've seen it in a couple of cases. But I understand why the perception is out there, and that's in part because arbitrators are human, and they don't want to leave one party completely without any result. And so it's human nature to try to please both parties. Okay? And go ahead, Stephen.
Well, I was just going to do a couple of things just to summarize back for our listeners. So the idea of an arbitrator is that you're going to somebody else and you're saying, we want you to decide for us what should be done. And that's different than going to court where you don't really have control over which judge is going to hear it, but here you can go and do it. And so that's one of the differences. But the thing that, Dan, that I'm really hearing you say that I think is important for our listeners is that the arbitrator is somebody who's hired to provide a service. And so sometimes they want to keep everybody happy, so they go and they try to split the baby, which may or may not be what folks really need. I think that's kind of what's going on between the lines, partially, isn't it?
I think that that can happen reasonably often. I think that's the fear, certainly, that attorneys have about arbitration. I think there's one other problem or concern about arbitration in our litigious society, and that is because the parties don't make the decision on the final decision themselves. They turn it over to the arbitrator. One party can be unhappy, and in theory, arbitration is supposed to end litigation. It's binding. That's supposed to be the end of the case. In practice, very commonly, or not uncommonly, the litigation continues. The case has to be affirmed by a court, and parties claim that it was unfair. And so there are risks associated with post-arbitration litigation as well. But the bottom line is, in litigation, you go to the court, you're going to get a result, you're going to have the opportunity to appeal, so it's not binding on the first go-round. Parties can appeal to a higher level of court. In arbitration, you get what the arbitrator decides, and in theory, it's binding. That's it. There's no appeal. In practice, sometimes there's subsequent litigation, although not an appeal often on the merits. And in mediation, parties resolve the dispute themselves, and they get their interest addressed. And so when they agree to it, they are very unlikely, extremely unlikely, to go into further litigation.
Right, because at the end, with mediation, you get a chance to figure it out for yourself. And then the other two, somebody else decides for you. So I think that's kind of the thing where that leads us to is so how is arbitration similar to mediation?
That's a good question, and it's very interesting. When I started in this field, 35 years ago now, many lawyers and almost all people not in the field did not understand the difference between arbitration and mediation. Often I would have to go in and explain the difference. They just thought both processes were alternatives to court. I think now, certainly lawyers, and I think most of society now actually understand the differences. And both, as I said, they have some they're very similar in some ways and very different in other. They're similar because they're both, you can design the process. Both arbitration and mediation allow the parties to design the process. So you can say the arbitrator will have to be an engineer or a scientist or a lawyer or whatever, and you can decide to have one or three arbitrators, and you can design how long the process takes. And same with mediation. both arbitration and mediation are done privately. They're not done by the government. So that's an important factor for many parties in many kinds of cases. That means they're confidential, or they can be. Parties can agree that they are confidential. Unlike litigations, court, where court litigation, absent unusual circumstances, the court filings are public. Excuse me. Parties, not the courts, pick who the neutral is, both in mediation and in arbitration. So you can get an expert, not a generalist, unlike in litigation where you get who the court decides. Arbitration and mediation are done by agreement with the parties, usually before the dispute arises, but sometimes even after. And both arbitration and mediation tend to be quicker and more cost-efficient than litigation.
Right, and that's sort of going back to the thing where if it's not done, if you don't have to go to court, you don't have to go to state court or be part of the federal system, you can do it on your own timeline. So if the arbitrator is available and everyone else is available, you can show up and do it whenever you need to, as opposed to whether or not you fit into the court's docket. And that's partly,
right.
And that's the same. Go ahead.
In many states, most states perhaps, certainly in the big industrial states, that's a major factor because the court, civil litigation in many states, the docket, the backlog before you get your case heard by a court can be years. In some states, 4 or 5 years. And you don't have to wait that long if you go to arbitration. You can design a system that gets you in before an arbitrator in 60 or 90 or 120 days, and you can require a decision by that arbitrator very quickly. So, again, a lot more flexible.
Yeah, so there's some very similarities in, you can the people who have the problem can pick who they want to work with, and they can pick in a sense how they want some of the things to be done from there. So, but how is those are some similarities that they have with mediation. What are some of the differences between arbitration and mediation?
Well, the first thing that's really fundamentally important is arbitration is binding. That is, once you've agreed to arbitrate, a neutral will make the decision for you. And so it's not your decision in a sense, it's the arbitrator's decision. Mediation, on the other hand, it's your decision. You only settle if you reach agreement to settle. Now, that's a double-edged sword. The good news is in arbitration you're going to get a decision. The bad news is it may not be your decision. In mediation, the good news is it's going to be your decision. The bad news is you're not guaranteed you're going to get a decision. The other thing is arbitration is not appealable. Once a decision made, that's it. Now, you only get one bite in the apple. The other difference is, and this is really very important when you get into the guts of the case, is in arbitration a single legal issue can change the whole result. Arbitrators generally make the decision based on the information presented to them and on the contract that establishes the arbitration procedure and sometimes on the law, depending on what the contract says. Some people claim they don't like arbitration because the arbitrator tries to pick the middle or throw the bone, but often an arbitrator, one legal issue or one contractual issue will throw the decision one way or the other, and parties may not like the results. In mediation, on the other hand, the parties negotiate a settlement with the assistance of a neutral. That means that they need to learn to speak to the other party in a way that that party can hear and understand why it's in their interest to settle. That's why mediators are often very effective. They're able to assist the parties to communicate in a way that the parties can understand why the agreement's in their interest. And I work a lot in parties, coaching them in private discussions and sometimes in group discussion on how to present their case in a way that the other party can listen to and understand. Arbitrate. The other piece of arbitration that I think people need to, when I train arbitrators and mediators, and I sometimes run the same fact situation as for people to see, and run it as an arbitration case, and then run it as a mediation case. And it's very interesting because the results can be quite dramatically different depending on whether you're mediating or arbitrating. Arbitration often does not get into relationship issues, business issues, how people want to deal with each other in the future. In mediation, all of those things are fair game.
Right, and that's really what I was noticing as I was listening to what you were saying is that arbitration, like going to court, the facts of the case matter a great deal in what the decision is and how it's going to, who's going to get what. Where in mediation, you could have a legal issue that's very much central to it, but there could be other things that are very important that are also going to make a big difference in how the decision's made. So that's a big difference between the two. Is that the law can sometimes make all the decisions, where in mediation, the people who are there will make the final decision. So I want to remind folks that you're listening to the Texas Conflict Coach on the Block Talk Radio program with your guest host, Stephen Kotev, and I'm joined by Daniel Preston Dozier, and we're discussing to arbitrate and split the baby or to mediate in the hot tub. So, Dan, when would you want to start using arbitration?
When would I want to start using arbitration?
Yes.
I would want to use arbitration in a case where, as you just described, the facts and the law are on my side. That's from a pragmatic. If I knew going before the results, that's what I'd want. But usually, you enter into an arbitration agreement or a mediation agreement long before you know what the facts and the law on your particular case are. So the other thing that's would be important is if you need a decision, a quick decision, a cost-effective decision, more important, more quickly, more than you need than the results of any particular decision. And the two areas where that is very common is in collective bargaining agreements, where employment disputes are grieved and arbitrated. And again, the important fact is not necessarily the merits of any particular one case, but that there's labor peace. Okay, so that's one area. Another very significant area where arbitration plays a major role is in construction disputes. If you're in a construction dispute and you have a dispute between a contractor and a subcontractor, you need to have that decision resolved quickly and finally, because the whole project can be held up if the dispute spills over and it begins to affect the schedule. So construction disputes and labor and employment disputes are two areas in this country where arbitration is very common. A third area is there are no international courts judges, essentially. There's no world Supreme Court. But there are international commercial arbitrators. And so almost all commercial trade disputes are decided by international arbitration. And again, that's a way where the parties can create private law, in a sense, enforceable law. And most countries have statutes that they've passed that provide for, as long as there are minimum standards of due process followed, where the arbitration awards are enforced by the courts of that country. And so, international commercial arbitration allows a neutral, that is, not the courts of one country, but, somebody that's maybe not from any of the countries involved in the dispute to make the decision.
Mm-hmm. So it sounds like arbitration is a good thing to have if you need a decision made quickly, that's final, that everyone's going to agree to. So, for construction, it's you got to get this building built, you got concrete trucks backed up, and you got a certain period of time for weather. So there's, before things get too cold, we got to get everything done. We can't spend a lot of time. Or if you're dealing internationally. So what happens for the other options that folks have? Say they were going to go and try to go to court, the traditional litigation route, or they're going to try mediation. When would folks want to try those other things as opposed to going and doing arbitration?
Well, I think the way people want to use mediation is in two areas. number one, they want to resolve, if the relationship between the parties is ongoing, and so they want to continue to have a relationship, whether it's a personal relationship, whether it's a business relationship, or whatever, then a mediation can be an effective way because the parties sit down at the table and resolve it between themselves with the assistance of the mediator. The other area is mediation is very much more cost-effective than litigation. You can resolve some very difficult and very complex cases in mediation and spend relatively small amounts of dollars, both on your attorneys and on the cost of the neutral, compared to what would it cost you if you went to a civil litigation. So mediation is very much more cost-effective than trying a case in court, and even more cost-effective usually than arbitration, unless you have a very truncated and expedited arbitration process. So there are two places where parties like to use mediation. One where the cost of litigation is extremely high. Let me give an example of that. I mediate and have for the last 35 years a number of complex environmental cases with multi-parties, and often these cases have large dollars at stake. And you'd think that those would be the kind of cases parties would not want a neutral to decide. They'd want a judge. Well, the fact is, while they don't want a neutral to decide that, they're uncomfortable with the judge deciding it, too, for several reasons. Number one, the kinds of cases I do are very fact-intensive, and the judges get overwhelmed with the paper, and parties, I think, have found that judges are not real comfortable with handling the large amount of data that some of these cases generate. And number two, it's just not cost-effective to litigate that. Because these cases involve so much data and are so fact-intensive, parties find that it works much better for them if they can negotiate a settlement. And the transactional costs of resolving the dispute then does not become a significant percentage of the total cost of the dispute. And in some of the environmental cases, the civil litigation costs nearly as much as what was in dispute, and that's certainly not a very good business decision to make. So when do they use traditional litigation? Well, still, by and large, most people don't think about their dispute resolution options before they have a problem. So, if you're sort of fat, dumb, and happy going forward, you're going to end up in court if there's a problem, because if you have a contract or if you have some sort of a relationship with somebody else, because you haven't thought about it. So that's one place where people do it, is when they don't think about it. They end up in court. If the other ways is if people think that a civil litigation, that they can't agree because either they think they can outspend the other side, and that certainly can happen sometimes, or if they believe that judicial precedent is important, or if they want to make new law, or rarely, but I have seen where they're not clear on the good faith of the other party in terms of participating in the process and disclosing information. But the information disclosure is usually not a problem, because parties have developed in the mediation process methods to provide for disclosure of wide, extreme amounts of information. And the benefit for that is it's confidential. It doesn't get filed in court, and so this information, it's easier for parties to disclose that way than if they have to file it in court.
Mm-hmm. So there's a lot of different things to consider depending on which way you want to go. For doing arbitration, it's something where it'll be faster probably than going to court. And whoever it is that is looking at the case, you're going to have some input as to whether or not they're the ones that are going to make the decision. And they're going to have a better understanding of, say you had a real estate problem, or you had a problem with something else, like an engineering, as you mentioned before, or construction. They're going to know that, and they're going to more quickly understand, well, why are you upset? The other thing is that if you wanted to try mediation or if you wanted to try litigation, the litigation end of it is if you just really don't think folks are going to participate in good faith at all, if they're just basically out to get you and you have no faith in them or any trust in them at all, then you take them to court. If you think that they're actually going to be there and they have something invested in the long-term outcomes of, either the business or the community or whatever other field or product it is that they're working on, then you go to mediation and you go and you try to figure it out that way. Does that sound right?
That's about right. I have to tell you, I represent, and my law firm represents parties involved or who are suing each other in court to collect monies that are owed under a contract. And it's very difficult in the courts. It's expensive. It takes a long time, and the results are uncertain. And the clients that I work with would very much prefer to resolve these things without going to court. And a lot of times they can, but not every time.
Right, and we talked about that in our prior shows, and if the listeners haven't had a chance to check those out, we strongly recommend that you do from today's show, because basically one of the things that we noticed was that if somebody else tells you, well, you owe this person you don't like a lot of money, you may or may not choose to pay them. But if you go in mediation and say, well, this is what I'm willing to pay, or these are my circumstances, can you work with me on them, then you're more likely to get, some sort of actual return on or follow-up with the agreement that you had, where in other circumstances, like, okay, you owe all this money, and then you got to go and see if they're actually going to give it to you, which, as you were mentioning, can be a lot of extra work.
The other thing is, and this is really true, you can talk to parties about their alternatives. Well, if we don't resolve this, if we don't resolve this without litigation, it's going to cost you a lot of money in terms of litigation, in terms of court costs and attorney's fees. So sometimes that brings parties to closure as well. The key to this whole thing, in my view, is before you choose litigation, arbitration, or mediation, to think about it if you're talking about a commercial dispute or anything involving a contract, think about it as you're writing the contract before the dispute arises, so you can design a system to handle it.
Right, and that's in a sense what would be your homework. If you were going to give an assignment for folks, it's to do that. And, one of the things that you mentioned as well is that some folks have signed arbitration contracts and they don't even know about it. There was some discussion about, say, for example, credit cards or with cell phone contracts. Those things are already built in and people don't have any idea about it. But that's one end of it. But I think what you're saying is that if the things that you're working on matter to you a lot, think about how you would go and fix them ahead of time as opposed to not doing that, and then you've gone and you've entered into agreement with somebody, and then you got to make up your mind, and it may not be exactly what you want. Does that sound right?
That's right. That's correct. Absolutely.
So how can folks find you, Dan?
My email is ddozier, D-D-O-Z-I-E-R, at pressdozierlaw.com. My phone number is 301-913-5200. And my firm's website is Press Dozier Law, P-R-E-S-S-D-O-Z-I-E-R, law.com.
And there's a way you can reach Dan off of our website as well. So, Dan, any last thoughts for our listeners about the fact and fiction around arbitration and versus mediation?
Yeah, I think I just went to the dentist earlier this week for my 6-month checkup, and like flossing when it comes to good dental health, thinking about dispute resolution in a when you have a relationship, an ongoing relationship with somebody, is good for your commercial and relationship health. If you're involved in a business relationship with somebody, it makes sense for you to think about what happens if this thing goes south. How can we handle it so that it doesn't kill everything?
So it's the same advice as you've gotten in so many other circumstances. What is it? Is an ounce of prevention is worth a pound of what is the end of it? Pound of flesh?
Yeah,
that's not the right word.
A pound of cure. That's and that's true for so many things in life. It absolutely is. And so I think that people need to think about that and think about it not just whether to do it or not, but whether to use arbitration, whether to use mediation, maybe to use both. I've seen a number of commercial contracts where parties have a clause that says if they can't reach agreement, they'll try to mediate it, and if they can't resolve the dispute in mediation, they go to binding arbitration. So there are lots of again, the value of alternative dispute resolution is one of the major values is its flexibility. You can design it to meet your needs in almost any kind of situation, whether it's even in a family matters. Parties, husbands and wives often find mediation is a much more effective way, especially if they're divorcing, but even sometimes on parenting plans or other things. Mediation is a very cost-effective way to resolve that rather than and by the way, mediation can teach you how to listen to the other party, and that in a marriage or in any kind of relationship is an important skill to learn.
Yeah. So there you have it, folks. You've got some great advice from a well-established and seasoned mediator and litigator who's also done some arbitration and been on both sides of the coin in that sense. So, Dan, thank you again for your third time on the show. It's been a pleasure.
It's my pleasure, Stephen. Thank you very much.
Thank you for listening to the Texas Conflict Coach. We hope you've enjoyed the program. You can find over 300 podcasts archived to listen at your own convenience at texasconflictcoach.com or download the podcast at iTunes or Stitcher Radio. To learn about upcoming radio programs and resources, sign up for our monthly e-newsletter.